Police often find criminal activity through traffic stops. That's no surprise. Looking beyond the scope of the initial stop and not ignoring warning signs of criminal behavior is a part of law enforcement officers' field training. Now, there are some misconceptions. For example, some officers believe that they must tell a driver that they are, quote, free to go, or something similar, prior to transitioning from a traffic stop to asking for voluntary consent to search. And while I don't have time to work through every misconception today, I can address this one. So in this week's video, we'll talk about Ohio versus Robinette, a 1996 United States Supreme Court case that answers this scenario. I'm Steve Serbalik, and I'm a panel attorney for ASCOPS in Arizona. Robinette was stopped for speeding on I-70 north of Dayton, Ohio. The deputy ran Robinette and found no prior violations. Robinette was asked to step out of his car. The deputy returned his license and Robinette received a verbal warning. The deputy then said, "One more question before you get gone." The deputy asked about anything illegal in the car, and Robinette denied having anything illegal. Robinette gave consent to search his vehicle, and the deputy then uncovered a small amount of marijuana and, in a film container, a pill that was later identified as MDMA. The deputy arrested Robinette and charged Robinette with possession of a controlled substance. Robinette fought the conviction, arguing that under Ohio law, the officer was required to clearly state that the driver was free to go prior to transitioning to a consent search. The Ohio Court of Appeals reversed the conviction, and the Ohio Supreme Court affirmed. The United States Supreme Court, however, disagreed, holding, quote, "The Fourth Amendment does not require that a lawfully seized defendant be advised that he is free to go before his consent to search will be recognized as voluntary. The amendment's touchstone is reasonableness, which is measured in objective terms by examining the totality of the circumstances. In applying this test, the court has consistently eschewed bright-line rules, instead emphasizing the fact-specific nature of the reasonableness inquiry," end quote. So while investigations pertaining to matters outside the scope of the original traffic stop can't delay the traffic stop, where the traffic stop ends and the consent search begins does not need to be marked by magic words. If you have any questions or comments, please feel free to leave them in the comment section below the video. Remember to like, subscribe, and turn on notifications to help my channel grow. Please share this video with anyone else that you know that you think might find it helpful, and be on the lookout for future videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching, and stay safe out there.